Economics Legislation Committee into the Taxation, Multinational, Global and Domestic Minimum Tax Imposition Bill 2024 and related bills. I begin by acknowledging the traditional custodians of the land on which we meet and pay my respects to their elders past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples here today. The committee will be conducting today's hearing via video conference and in person. These are public proceedings being video streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. I remind committee members and witnesses who are appearing via video conference and who are not speaking to please mute their microphones. I now welcome representatives from the Corporate Tax Association, Herbert Smith Freehills and the Australian Securitisation Forum. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, we'll have you state your full names and the capacities in which you appear today, and we'll begin with the Corporate Tax Association, then Herbert Smith Freehills, and then the Australian Securitisation Forum.
Thank you, Chair. Simon Staples, Assistant Director, Corporate Tax Association.
Paul Sapri, Assistant Director, Corporate Tax Association.
Graham Cooper, Consultant, Herbert Smith Freehills.
Excellent. I'm not sure whether each of you was going to give an opening statement. I'll start with the Corporate Tax Association and just given the time, if you have one, we're happy to hear it. But yeah, please keep it brief.
Senator, could you just confirm that you can hear us from the Securitisation Forum, please?
We can, yep.
Thank you.
Do you have our video?
Yes.
Would you like us to announce ourselves then?
I thought you did. Go ahead.
Christopher Dalton, Chief Executive Officer of the Australian Securitisation Forum.
And David Wood, Partner, King and Wood Mallisons for the Australian Securitisation Forum as well.
No problems. Thank you and apologies for that. If the Corporate Tax Association would like to go ahead.
Thank you, Senator. We'll just make a short opening statement and thanks for the opportunity to appear and provide evidence at this hearing. The introduction of these bills to the House of Representatives and the subsequent referral of the bills to this committee is a significant milestone for Australia in this complex and long-running process. It's particularly important given that the rules do apply to fiscal years commencing on or after 1 January 2024. We acknowledge the importance of the OECD in its role as a multilateral forum for progressing global tax changes and Australia's ongoing support and commitment to implementing these rules in our domestic legislation. The importance of the OECD's approach is reflective of the fact that several jurisdictions have now implemented a version of the rules that now brings their tax systems in line with some OECD baseline norms. For Australia, where the headline corporate tax rate is 30%, implementation of the model rules is as much about ensuring Australia is part of a global solution, as well as ensuring that a small number of taxpayers will pay a baseline of 15% tax. This was confirmed by Treasury's impact analysis statement, which also estimated that 97% of companies will be required to incur significant compliance costs, but not pay any extra tax under this regime. It is therefore important that an appropriate balance is struck between ensuring Australia's regime is qualifying and that ATO and taxpayer resources and compliance costs are not disproportionate to the revenue forecasted to be collected. We'd like to note that since making our submission to the committee, we've also had the opportunity to meet with Treasury and the ATO on these bills and the subsequent rules, and further clarification and guidance has been discussed with both those departments, and as such, some of the issues in our submission are less of a priority to resolve. In closing, we'd also like to note that the implementation of these rules is a two-part process: the bills before the committee and the broader rules which underline the mechanics and the calculations for these rules to apply. Given that the subsequent rules will be a disallowable legislative instrument, and they are the critical factor to the operation of the rules, we do wish to see those rules also be subject to some parliamentary scrutiny, whether it be through this committee or some other process. However, we do understand that might not be possible given the timeframes and the broader process of disallowed instruments. And as such, we would also like to add a recommendation to our submission that a post-implementation review be legislated. Thank you, and we'll welcome your questions.
Thank you very much. Did Herbert Smith Freehills have any opening statement?
Thank you, Chair. You will have seen from our submission that we, like all of the other people who've made submissions in this, don't really have any quarrel with the underlying policy, although we do think it important to draw to the committee's attention the prospect that embarking on this path will provoke retaliation from the United States. The impact analysis in the explanatory memorandum says Pillar 1 will avoid the trade war that enacting digital services taxes might have provoked. The impact analysis doesn't acknowledge the efforts in the United States at the moment to provoke an income tax war against the local subsidiaries of any country that enacts Pillar 1 or the UTPR. So one should not discount the possibility that the United States will change its stance from indifference to hostility. Pillar 2 can withstand indifference. It probably can't withstand hostility. You will have noticed also that we don't make any submission on the content of the model rules because essentially the Australian Parliament is largely powerless in this space. Our legislators are being presented with a take it or leave it proposition, and I think it's fair to say Australian businesses would not be enthusiastic to see Australian legislators tinkering with the rules, and it would certainly not be in Australia's interest to modify the rules such that our rules were no longer qualifying. So instead, our submission focuses just on the manifestation of these bills in Australian domestic law, the areas over which Australian legislators have control. And so we've emphasised three things. The first is the curious and haphazard way in which Australian law will treat tax collected under these rules in foreign countries. And the Corporate Tax Association submission alludes to that as well. The second is the way that the joint and several liability aspect is going to cause enormous difficulties for relatively straightforward commercial transactions. And the members of the Securitisation Forum are talking about one manifestation of that problem. The third thing we talk about is, I will leave for another day, but I'll just draw the committee's attention to the point. If these rules really do work, they render OTOs other parts of the Australian income tax system. The government has already decided it will not proceed with the intangibles measure because of Pillar 2. There are other measures that are currently in play that could simply be eliminated. And with that, I will stop my comments.
Thanks, Professor. And the Australian Securitisation Forum?
We would like to request whether we could make an oral submission as we haven't provided a written submission to the committee.
I don't know what you mean by that.
Well, we would like to make an extended sort of commentary at this point rather than have provided a written submission.
So Thank you, Mr. Wood. So we've got about 1 or 2 minutes for an opening statement, but you're absolutely welcome to table for the committee any extended documents that you have. So you've got one minute for an opening statement, and you can table your document, and it will be considered by the committee.
Yeah, thank you, Senator. We'd just like to say at the outset that the Securitisation Forum is focused very much on the joint and several liability rules in the proposed legislation. We note that securitisation vehicles depend for their ratings and their effectiveness as a vehicle to lower interest rates in terms of financial repackaging, that it is very important that they are insolvency remote, and that very much in turn depends upon not facing unexpected liabilities. In the normal sense, a securitisation vehicle is able to accommodate existing tax rules relating to trusts and companies to show that the vehicle itself will not be subject to anything which is unpredictable by way of tax liability in terms of both quantum and timing. The way the proposed Pillar 2 rules work, where you identify a constituent entity of which a securitisation vehicle might be one, if it belongs to a multinational enterprise of the relevant threshold, might be an entity which could be potentially subject to a Pillar 2 top-up tax, and therefore it would be something which is not able to be predicted because it depends very much upon the activities and effective tax rates applicable to another entity in a low tax jurisdiction. And we note for the committee that the OECD recently published in its June guidance that securities entities should not be taken into account as an entity subject to the impost of a top-up tax. And we would say that the Australian legislation should adopt a similar policy. And we also submit that that policy and drafting can be already found in Section 82039 of the Income Tax Assessment Act 1997, which the Parliament previously adopted in recent capitalisation changes to exclude securities entities from those changes as well. And so I'd welcome further questions, and we'll make a submission in due course. Thank you.
Thank you. So just for clarification, if you provide your document to the Secretariat, it will be considered as part of this inquiry. So thank you. I'll just start just with a couple of questions for the Corporate Tax Association and then share the call with the Deputy Chair. From your submission and your opening statement, you're broadly supportive of the measures and you've raised some questions around implementation and the disallowable instrument and getting the balance right, if I could put it broadly like that. Just before I come to those latter issues, are you able to just share with us why it is important for Australia to be part of this global regime and try to work with the global community on addressing the race to the bottom on corporate taxes?
Sure. Thank you, Senator. Simon Staples, Assistant Director, Corporate Tax Association. I guess the broader question that you ask is around Australia's involvement. Preface our answer with saying that is probably a matter in the government's eyes or successive governments. Being part of as a global solution, I guess, as a leader, as a well-developed country and a well-developed economy is part of that broader, I guess, political environment. Notwithstanding Mr. Cooper's comments about trade wars and the like, which shouldn't be neglected, this has been a long-running process, kicked off, I think, around 2008, culminating around 2016 and then into 2021. So there has been a lot of negotiations. We can only imagine at the OECD level, where Australia has been represented, as we understand it, we are not privy to those discussions about how these rules have ended the way they are, but it is Australia as, I guess, a G20 leader of sorts to, be part of an example setting to bring other jurisdictions to the table and put in a minimum tax rate. That's probably reflective if across the African nations, so across the ATAF area where the representing the African nations have put in place or going to put in place a 15% minimum tax. I suspect before this there wouldn't have been that sort of narrative in some of these other developing nations. So in that sense, being part of the solution and being supportive of the solution has probably been a key element in our mind.
Thank you. And so you're supportive of the minimum taxes being rolled out and Australia participating in that regime. That's right, isn't it?
Yes, absolutely.
Yeah. And so we've got around 60 jurisdictions in the world who are sort of leading this process, and Australia's part of that group. You've said that you have been raising some issues with further consultation with Treasury around implementation and the disallowable instrument. Do you want to take us through, I guess, what those headline issues have been and what progress you've been able to make in those discussions?
Yeah, certainly. One issue has been raised in both Mr. Cooper and the Securitisation Forum is around joint and several liability. So if we may, we might park that issue, as I suspect you will come back to it. Of the other issues that were discussed in relation to the primary bill, there's two specific issues. One is in relation to unincorporated joint ventures and the lodgement of what we call a domestic minimum tax return. That has been resolved now in the legislation. It's in specific the insertion from the exposure draft of section 128-25 sub 5, which makes it pretty clear. I do note that these are quite complex provisions, and trying to map where all these different aspects are is quite challenging. So, where to the extent some of these things can be supported with guidance in a clear and concise manner, potentially on the ATO website or through other means, would be welcomed. The other challenging issue that we were struggling with through the various ranges of consultation has been on the notion that the Commissioner can compel a taxpayer to provide a global information return. The way the rules work is that a global information return can be submitted anywhere in the world, in essence. And then Australia, if it's not an Australian headquarter or hasn't been filed in Australia, can access information specific and relative to Australia's calculation of a domestic minimum tax. The drafting in the bill to the way of trying to fit, I guess, a international set of rules into our domestic and statutory frameworks has been quite challenging. We should note that Treasury has done quite a strong job in getting that, to try and fit as best we can. We do acknowledge that. Unfortunately, when you have some defined terms that have quite broad definitions, it becomes challenging. Initially, the way we read the provision was that Australia would be seeking to acquire all the information, the global information return. From our last conversation, it's been clarified that no, Australia would only be seeking to obtain information that is relevant in line with what the OECD recommends through the relevant administrative guidance. That said, we do still find it challenging that a taxpayer, if subject to the rules and subject to this provision applying, would be subject to penalties. They are significant global entities, so penalties are doubled. And really it's because of the failing of administrators being able to work together in this regime. And so we do think that is onerous and burdensome on a taxpayer to be levelled with such penalties when it's not a failing of the taxpayer. They've complied with international laws, Australian laws, and that's the biggest challenge left in that provision.
Senator, there are a couple of other issues I just may quickly mention. One is the use of the ultimate parent's financial statements is a critical matter which we feel is necessary. We understand that's probably something which may move, which is welcome. And the second rather technical issue deals with the treatment of indexation of certain secondary taxes, particularly PRRT and the equivalent taxes in the UK and in PNG, and whether the indexation factor associated with the way you calculate what's called a deferred tax asset is calculated as part of the the underlying effective tax rate, because it can have an impact of depressing that and effectively having tax paid when probably shouldn't be subject to a domestic minimum tax or top-up tax in Australia.
And as we said, Chair, the joint and several liability issue is definitely front and centre on this.
Thank you. Thank you both for that. Senator Bragg.
Thanks very much. So everyone's happy with the 15% in theory, is that right?
I assume, Senator, that might be a question for the Corporate Tax Association. Yes, I mean, it's subject to international negotiation. I'm not sure it can be higher or lower. That's what was agreed to, I think, by over 140 countries as part of this multilateral approach.
Yeah, so do you think the US is going to adopt this 15% minimum tax rate?
I maybe might defer that to Mr. Cooper, who's probably more across the US stuff than I would be.
So the US already has a corporate alternate minimum tax, which is set at 15%, but it's not a qualified domestic minimum top-up tax or a qualified income inclusion rule. So we don't view it as adequate. But the US has gone down 15% on worldwide profits calculated on a worldwide aggregated basis.
Okay.
The OECD, I'm sorry.
So with the Securitisation Forum, what are the amendments needed to protect securitisation?
Thank you, Senator. We believe that the matter can be addressed by excluding entities which satisfy the definition in Section 82039 of the existing thin capitalisation rules from being an entity which could be potentially subject to both primary and secondary liability under these rules. That we regard as consistent with the OECD's recent publication in June of this year, Chapter 6.
All right, so you think you can amend this thin capitalisation rules?
We can adopt them, Senator.
So you think you can leave in place the 15%?
Yes.
But effectively allow securitisation to occur with some changes to the thin cap regime. Is that what you're saying?
Well, using the definition which is found in the thin capitalisation regime, we believe that could be adapted readily to exclude the securitisation vehicle for being a constituent entity which is subject to potential top-up taxes on either a primary or a secondary liability basis, Senator.
Okay, so you're suggesting that you could leverage or you can use that as a precedent?
Yes, Senator. We believe that those rules have been very carefully crafted and they've been in place now for over 20-odd years to suit the Australian securitisation landscape, and that the definitions which you find in the recent June publications by the OECD really aren't crafted for the Australian securitisation environment. They're more specifically aimed at the tax regimes in other parts of the world. So with adopting what's an Australian solution or a solution to their securitisation, you can achieve the same policy thrust found in the OECD publications.
So what do you think is the outworking if there are none of these changes made? I mean, what happens to securitisation in Australia?
Yes, Senator. We would say that the securitisation depends very much upon being able to provide instruments which have been rated by rating agencies according to their guidelines. And that depends very much upon being insolvency remote. And that takes into account that tax liabilities, amongst other things, are not going to fall upon the entity in either an unpredictable way as to both timing and quantum. In the normal course, a securitisation vehicle is a trust, and that trust usually has the trustees not subject to tax because the unit holders in the trust are subject to tax. So the profit made by the vehicle is actually not taxed to the trustee, it's taxed at the unit holder level in normal course. And you can provide the opinions to rating agencies and the professional trustee companies that those exemptions are available and that there should be no, there's certain that there is no tax liability incurred. And the same applies if those vehicles are actually in a consolidated tax group because they would be signing a tax sharing agreement which then relieves them from joint and several liability and imposes instead a reasonable allocation of the overall group's liability. But because the trust is in the normal course, if it was a standalone entity, not subject to tax, but the tax applies at the unit holder level, our opinions to those trustees and rating agencies is to the same effect, and they have confidence in those opinions. The Pillar 2 Globe rules work very much in a different way because they are effectively a mechanism to collect tax which has not been sufficiently paid by an entity in a group somewhere in the world. So the possibility is that a securitization vehicle, which is a constituent entity of a multinational group subject to these rules, might find that they are imposed a level of tax by reference to being a constituent entity where there is a low taxed entity in the group. And that's something which is unpredictable. It doesn't have anything to do with the activities of the securitization trust. It's something which you cannot give comfort to the ratings agencies or the trustees that there is not going to be this income tax from the activities of this entity. It just turns up by reference to an activity of the multinational group somewhere else in the world and according to an allocation regime which is itself quite unpredictable as well in our view. And these things make it very difficult then to provide the rating agencies and vehicles trustees themselves with the comfort they need to continue these transactions, which do have the benefit of providing a lower cost of funds for the institutions, the lenders, which ultimately access securitization to provide home loans, commercial loans, leasing facilities, etc.
Okay, thank you.
Thank you very much, Senator Bragg. That concludes the questions that the committee has for you today. We very much appreciate you providing your submissions and answering our questions today, and we ask that you now disconnect from the video conference. Thank you.
Thank you.
Thank you.
I now welcome representatives from the Treasury and the Australian Taxation Office. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. As you come to the table there in Canberra for us, the Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to a superior officer or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Commonwealth officers appearing today are also reminded of the Senate order specifying the process by which a public interest immunity claim could be raised. A copy of the order is available from the Secretariat. I think that I will ask you there from Treasury and also the ATO to just go ahead and state your names and the capacity in which you appear today. Thanks.
Thank you, Chair. Catherine Davey, Assistant Secretary, International Tax Branch.
William Potts, Director of the Pillar 2 Unit in the International Tax Branch.
Tanya Coit, Director of Law Division.
Hector Thompson, Deputy Commissioner, International Support and Programs, the Australian Taxation Office.
Louise Andolfado, Assistant Commissioner, International Support and Programs, Australian Taxation Office.
Caroline Arman, Acting Assistant Commissioner, Law and Policy Design, Australian Taxation Office.
Great. I think that was everyone, and thank you all for appearing. I'll just start with Treasury. The bills establish a legislative framework, and then a significant amount of the detail is in regulation. Can you take us through broadly what detail is included in the regulation and why that particular approach has been taken?
Certainly. Thank you. So the decision to push quite a bit of the detail into the subordinate legislation was a deliberate design choice. That detail is largely how you compute the amount of top-up tax that will be imposed. And that's quite a detailed formula, much of which is already provided in the OECD model. So the reason for the design choice was that the OECD model is continuing to evolve. So just in June of this year, we received the fourth iteration of administrative guidance since the model rules have been released, and we knew that the rules were going to evolve over time. They're large, they're complex, that's not unexpected. So designated those details to the subordinate legislation allows an appropriate degree of flexibility to be built into Australia's regime in a timely and efficient manner. It also ensures that it retains a sufficient degree of parliamentary oversight. So we've been quite open about this approach from the outset, and we've outlined that in paragraph 24 of the explanatory memorandum as well to the bills, and specifically noting what I've just outlined above. And so when working with industry, we've made this quite clear, that would be our approach, and that was from the inception of the Pillar 2 solution. So in the development of the rules, we've been working with the subgroup of the Digital Tax Working Group. Late last year and earlier this year, we engaged in public consultation and targeted consultation in the development of the bills and in the development of the rules, and we'll continue to do so. And we've released the exposure draft of the rules for an extended period, which was an 8-week period. And so we're continuing to undertake this consultation so that people are aware of the details and hopefully to reduce any unexpected surprises in the rules. So we're trying to be as open and transparent as we can about the detail, which is set out by largely by the OECD model.
Thank you. So these bills are part of Australia's response to the OECD G20 inclusive framework and particularly Pillar 2. We know that many countries are signed up. There are around 60 countries, I think, that are taking this first step. We had some commentary from the previous witnesses about the sort of parallel but different approach that the US is taking around a 15% minimum tax rate. Can you talk us through what stage of implementation the world is at with these measures broadly, and whether there are any challenges to Australia of the way in which the US is looking at minimum tax as raised by witnesses?
Yeah, thank you, Chair. As of now, approximately 66 jurisdictions have either announced, released for consultation or introduced legislation for the implementation of a global minimum tax and or a domestic minimum tax, including major jurisdictions like Canada, the UK, the EU, Japan and New Zealand. 33 jurisdictions have introduced legislation with a 1 January 2024 commencement date, and the remaining jurisdictions either have an earlier, a later, or they have not been entirely clear on the start date for their legislation. The US has indicated they won't implement a global minimum tax and will instead continue to use its global intangible low tax income rules, or GILTI, and its corporate alternative minimum tax, or CAMT. And broadly, we're aware of the US Republicans' position regarding Pillar 2, and of course we monitor that, but reiterate that Pillar 2 is currently being implemented by over 60 countries, and it is a multilateral effort. Beyond that, I wouldn't like to speculate about what might happen in the future depending on an election outcome in another country.
Fair enough, thank you. You've already talked a little bit about the consultation process that you've been through, and the Corporate Tax Association indicated that they've been working through some of their input into the bill. Can you tell us what changes have been made to the bill that's before us broadly in response to the consultation?
I think largely during the consultation sessions we've been workshopping a number of technical issues, and a lot of the detail is so complex that it really requires working through each of those issues in detail to understand, and certainly for Treasury to understand how they operate in practice. And that's, I guess, been the focus of our workshops, to really understand how practitioners are applying, would see these rules applying in their certain circumstances. So I think what you see before you in the bills is a product of that consultation and partnering with our industry representatives to, I guess, really clarify the wording in the model rules. Much of the model rules are written as a result of negotiations between the 140-odd inclusive framework members, and therefore they don't always use wording that will achieve the objective that was intended, and therefore testing those rules is been highly important to make sure that when we introduce the rules into our legislation, subject to it passing, it actually will achieve the intended policy outcome. So a lot of the design has been from that. There's also been clarification on, you'll see the consequential bill is very much about the interaction between the Globe rules and Australia's Income Tax Assessment Act, looking at things like franking and foreign income tax offsets. And so really that clarification, I guess, some of the issues that we've been working through with industry stakeholders.
Okay, I'll just go to the ATO briefly, then go to the Deputy Chair, and if I have time, I've got a couple more questions for Treasury, but just quickly to the ATO. Can you talk us through what consultation, if any, at this stage you've been having with firms which may be covered by these rules about the rules coming and their compliance, and related to that, what work has the ATO undertaken or will it undertake around guidance if and when the bills pass?
Thank you, Senator. Hector Thompson, International Support and Programs. So the ATO has been working for some time on this measure, obviously concurrent with the legislation process. From the ATO's perspective, the main focus of that work has been around the administration, in particular the lodgement. So, it is a complicated change to the international tax system. It does mean that in-scope entities will be providing much more information across a wider range of their organisations, and bringing that together in a lodgement either to the ATO in the case of entities that nominate the ATO as the tax administration they wish to lodge with, but also with tax administrations around the world. So in addition to focusing on Australian lodgements, we've also been working with other tax administrations around the globe because they will obviously be receiving lodgements as well. In terms of I think you asked specifically about the consultation, so I might hand to Assistant Commissioner Andolfatto, who has been leading those consultations with industry from the ATO's perspective.
Thanks, Hector. Yes, so last year, following the budget announcement, we set up a Pillar 2 domestic working group in the ATO, and we engaged in 3 rounds of consultation. It was a phased approach to consultation, so we engaged with potentially affected MNEs, their advisors and industry groups. So in those rounds of consultation, the focus was largely education and awareness, because obviously we didn't have any public exposure draft at that stage. We were concentrating on just awareness of the implementation dates for the measure, and broadly what was expected in the Globe rules by way of administration, and then what the ATO approach to administration was likely to look like, including what domestic tax returns may be necessary, and also awareness about the Globe information return and the requirements around lodgement. So that was the first phase of consultation. We also asked around preparedness for implementation and what companies were doing to get ready for introduction. We asked what potential advice and guidance topics they might like to see from us, and we asked whether there were any other additional concerns they wanted to raise in terms of administration or potential, I guess, what they might want to see from us in terms of assistance with obligation compliance.
Okay, thank you.
That was the first round of consultation. Following that, we did publish our findings on our consultation website and on our ATO Pillar 2 website, if anyone's interested.
Just finally from me, unless I get more time later, to the ATO, how do you see these measures interacting with the other measures in the multinational tax integrity work that the government's doing to perhaps shape compliance and collections from multinationals?
So what I would say is that these are very much a global set of rules, and I think in the testimony you heard from the Corporate Tax Association, they provided an example of corporate taxes being introduced in Africa, I think. And so what I would say about this particular measure is its success will depend not so much on behaviour in jurisdictions that have a higher headline tax rates, such as Australia, so we're talking about a 30% headline rate in Australia, but in those jurisdictions that either didn't have corporate taxes in place or that had corporate taxes at a level lower than 15%.
Thank you. Deputy Chair.
Yeah, thanks very much. So just to Treasury, so just ask some pretty basic questions. So this is a 15% proposal which applies to which companies exactly?
Thanks, Senator. So it will apply to companies who are part of multinational enterprises, that is, they operate in more than one jurisdiction, and that multinational enterprise has a turnover of more than 750 million euro, which is about $1.2 billion. So that's the scope of companies it will apply to. It applies broadly. It applies to all sectors. There's no sector which are excluded. There are some types of excluded entities, non-profit organisations, government entities, international entities, and also international shipping income is excluded. So it applies broadly to companies which are members of large multinationals.
Is it $1.2 billion global revenue?
That's right, yes, Senator.
Global revenue, okay.
Yes.
How many of those companies are there in Australia?
Sorry, Senator, we may have held.
Just a moment. Senator,
it's a pretty basic question.
Yes.
Seeking to impose a new tax on companies. I would have thought you'd know how many companies you're seeking to impose this new tax on.
Yes, Senator, based on data from 2018, the OECD estimates that the international implementation of these rules would collect revenue from an estimated 7,000 in-scope M&E groups worldwide. There were around 5,000 M&E groups, both Australian and foreign parented, whose members self-report as significant global entities based on 2019-2020 data. However, not all of these entities will be subject to Pillar 2's global and or domestic minimum taxes. This will depend on the amount of tax currently being paid, whether or not the entity or its income from certain activities has been excluded from the scope of the Globe Model rules, and such things as the value of tangible assets held.
So how many?
We don't have a precise number, Senator, and it wouldn't be possible for us. There are around 5,000 M&E groups that could possibly be caught. William, do you have any further information?
The 5,000 are the numbers of the groups which fall within the scope, and as we've said, the question of whether they will pay tax will obviously come down to the level of tax they pay now and such things as the extent of their tangible assets in Australia.
Okay, so you're talking about 5,000 companies in Australia.
That's the maximum number, Senator.
In case it's helpful, Senator, obviously the majority of those will be foreign headquartered companies. So the number of Australian headquartered entities that would be within scope will be much smaller.
Sure, but there are 5,000 companies that are doing business in Australia that I assume that they have to have a commercial footprint in Australia for it to be captured, right?
Correct.
Right, okay. And so what's the gain or loss to revenue from this new measure?
It is 370 million over the forwards, Senator.
Yeah, is that gross or net?
That's gross, net 259 million over the forwards.
Okay. Has the US put theirs in place yet or not?
No, Senator. As I explained earlier, it's well known that the US is not intending to implement Pillar 2.
They don't need to, they say?
Well, they have an existing regime known as guilty that they intend to rely on.
Okay, that's fine. So about 5,000 entities, a couple of $100 million on a net basis. And so what's the major problem here? Is it the issues that have been raised by the Securitisation Forum? I'm trying to find out what the fly in the ointment is here. Have you met with the Securitisation Forum?
Yes, we have met with the Securitisation Forum. They've got a specific or a particular issue, Senator, and I suppose basically their argument is because of the way a securitisation vehicle, or its purpose and the way it is designed, they are seeking to have a securitisation vehicle excluded from the scope of the rules.
I mean, what do you think?
We are considering the issues. We understand their proposition. We're considering the issues they have raised. I think it's important that anything that the government may do to accommodate the propositions by the Securitisation Forum don't have the result that our rules aren't seen as qualified by the OECD and other jurisdictions. So that's an important issue. I heard the evidence earlier, and I were aware that the Securitisation Forum are seeking to have securitisation vehicles excluded, but more particularly they want to use they argue that an existing definition in the law, in Australian law, should be used. The concept of a securitisation vehicle at the OECD, they have a different definition, which on the face of it looks narrower than Australia. So there is certainly a concern from us as policy advisors that if we use that wider definition to however the government may seek to respond to the securitisation issues, that could result in our domestic minimum tax not being seen as qualified. And I think the evidence from the Corporate Tax Association was that it was important that our rules be seen as qualified and fitting with the model rules.
Well, everyone would agree with that. But my question is, did you meet with the securitisation issues people before the bill was introduced?
No, Senator. Those issues was brought to our attention after. That's right. After the introduction of the bill. Yes.
I might also add, though, that these issues that have been alluded to are in the latest iteration of the guidance that has been released by the OECD in June this year. So they're a matter that we are looking into as part of the further development of the rules. So it's an ongoing matter. It's not a matter that is, I guess, existing in the current bill.
Sure, but like the securitisation people are saying that if you proceed with this bill unamended, then it could seriously impact the viability of securitisation in Australia. So is that something that you're considering providing advice to government on?
It's a matter that we're working through, and we'll certainly engage with the Securities Forum to do that.
Yeah, okay, that's great, thanks.
Thank you, Deputy Chair. Can I just clarify on that last sort of question and answer that you think that securitisation matter is enlivened in the regulations rather than in the bill itself? Is that right?
I wouldn't say that it's enlivened. I would say that this is a matter that has come to our attention after the bills were introduced into Parliament, I would say. It's something that, I need to check that time frame, but it's something that has been raised recently. It's not something that we were working on in any great depth prior, and we've had further guidance that elaborates on the issue of securitisation that was released in June 2024. We've written the bill to say that our legislation is to be interpreted in a manner that is consistent with the OECD documentation from time to time, and that's what we're intending to do.
Yeah, I think your answer when we review it on Hansard is probably enough for the committee. All I was trying to ask is this matter appropriately dealt with in the regulations? And it sounds like the answer is yes.
We haven't come to that conclusion yet. It's a matter that we are working to work out if it can be appropriately dealt with in the regulations, and that's something that we haven't formed an opinion on yet. And the regulations, as I understood it, have been
or the detail, as you gave evidence before, has been left to a disallowable instrument rather than put into the primary legislation for the reason of this being a sort of iterative process with the OECD, and the need to retain the flexibility for matters like this as they may arise.
That's exactly right, Senator, yes.
Okay. Just one last general question from me is there was some theme that is not unusual in inquiries like this around compliance burden issues, and I just wanted to understand from Treasury how the bill and the consideration of the disallowable instrument reflect an effort to address compliance burden issues or to minimise compliance burden.
Thanks, Chair. So we are certainly aware of the potential compliance costs facing MNEs, and that was kind of set out or acknowledged in the impact statement, which was on the two-pillar solution, which was published in May 23 and forms part of the explanatory memorandum. I think it should be noted that irrespective of whether Australia implements these rules, MNEs will largely face the same compliance costs, assuming that it's going to be, there's 60 other countries which will be implementing these rules. So you could look at compliance costs, whether Australia legislation imposes, say, any further marginal costs, and we probably does, but I'd argue it's not significant. The significant compliance costs come from the fact that it's been done worldwide. The legislation has been designed to the extent possible to largely reflect both the language and the structure of the model rules. So that we see that as a way of reducing compliance costs because they are the rules which are known kind of worldwide and which the multinational will be implementing in other jurisdictions. And also the use of subordinate legislation, as Mr. Coit explains, allows that flexibility to make sure Australia, shouldn't say make sure, but to the extent possible, again, to make sure Australia's legislation is up to date with the rest of the world.
Just finally, and in the context of these being global rules and the interaction with the OECD, there was suggestions of a risk of not qualifying, of Australia sort of not qualifying. And I understand that there's a sort of a peer review process on these rules. Is it expected that this bill would receive, the qualification status in that process?
Thanks, Chair. So, as you point out, there is a peer review process, and the way that is being conducted, there's initially 3 review processes, and that is on the 2 main rules, the income inclusion rule and the under-tax payment rule, and also on our domestic minimum tax. So they're running the processes separately. We have submitted our legislation for the income inclusion rule. The process of that is largely complete within the OECD. We expect Australia's outcome, the outcome for Australia and a number of other jurisdictions, around 20, to be made public later this year by the OECD. we expect that we will be seen as qualified in that initial for the income inclusion rule. We've also submitted our forms for our domestic minimum tax. That process hasn't concluded at the OECD. We would be, I was going to say hopeful, more than hopeful. We would expect that we would qualify under domestic minimum tax. The third process regarding the under tax payment rule hasn't started yet, and largely that's because the under tax payment rule will not commence for 12 months later. It doesn't start to 2025, so the OECD's put that process off. But in short, we would expect that, and we've been very conscious of this in drafting, and to reflect that and make sure that we reflect or obtain the outcomes in the model rules. So yes.
Okay, thank you. That concludes the questions that we have for all witnesses today. The committee has agreed that responses to questions on notice should be provided by 12 noon on Monday, the 12th of August. Thank you all for your evidence today, and you go with our thanks. The committee stands adjourned.